My background is as a journalist. I started off at the Bergen Record in New Jersey before going to law school. And I went to law school to do this kind of thing, work with journalists and protect journalism. So I'm happy to be here. And today I'll be talking about how to protect journalism from legal risks. So first of all, the annoying lawyer disclaimer I need to give is, this isn't meant as legal advice. It's more practical advice about what to be aware of as a journalist. And then if you need legal help in a particular situation, you should consult an attorney. You're always welcome to reach out to us at the Cornell Clinic or any other attorney to get legal advice. So, protecting your journalism. I want to cover four kind of broad issues. First is avoiding defamation risks. And I'll be focusing a lot of the time on that for two reasons. First, talking about defamation kind of wraps up a lot of other topics in it. So although the general focus here will be defamation, we'll be covering lots of other ways to protect your journalism as well. But also, defamation lawsuits are still really the most common legal risk that journalists face. And in some ways, they're becoming more common. As I'm sure everybody knows, there's been this rise in politically motivated defamation lawsuits where sometimes the plaintiff doesn't even think they have a good case. There's no real argument that they have a good case, but they're filing a lawsuit so that they can show people they're suing the press or whatever. So defamation risks are probably the biggest bucket of potential risks that journalists face. And then I'll also talk about other important things, thoughtful communications internally, so that there aren't internal communications within the news organization that might come out later and be skewed, be misinterpreted to increase legal risks. Then I'll also talk about shielding information about sources. I mentioned that case we recently had to protect an anonymous source, and I'll talk a little bit about the law in that area. And then recording the police and recording in public spaces. It's another important thing to know these days. So starting off with defamation, and the good news about defamation is truth is an absolute defense. Of course, if what you write is true, then you're not liable for defamation. And even beyond that, the defamation law aligns really well with standard ethics and practices of journalism. So even if you make a mistake, defamation law will still protect you as long as you can show that you followed basic journalistic standards. So things like having multiple sources to confirm facts, carefully and thoughtfully editing and reviewing work before it's published. If you write something negative about a person or an organization, giving them a full and fair opportunity to respond. If you can show you've done those things, even if there is an error in the work, you generally should be protected under defamation law. So for somebody to prove that you're liable for defamation, they have to show each of these elements. And I'll go through each of the elements one at a time, but they have to show that you made a false statement of fact of and concerning them. They have to show that the statement of fact harmed them and that it was published with a certain state of mind. They have to show either you acted negligently or you acted with actual malice. So I'll talk about each of those one at a time. First, this falsity element. This is the idea that truth is an absolute defense. As long as it's true, it's not defamatory. But also, as long as it's substantially true, it's not defamatory. So as long as the gist of what you published is accurate, it's still not going to be a defamatory statement. However, kind of the flip side of substantial truth, the flip side of this idea that as long as it's essentially true, that as long as the gist is true, it's not defamatory. There's also this idea of defamation by implication. And this is somewhere that news organizations sometimes get tripped up. Because with defamation by implication, even if everything in the article is literally true, there might be an implication in the article that is not true. So there might be something where a reasonable reader would come away thinking something that's not true. And if that implication is defamatory, you still might be liable for defamation. So where this comes up a lot is with juxtapositions. So putting two facts next to each other that don't belong. One possibility is with like the design of a news page. If there's a headline saying, somebody was found guilty of some crime, and then there's a photo of a person, and the photo is meant to go with an unrelated story, but because of the design, it looks like the photo goes with the headline. And it is saying that the person in the photo was the person convicted of the crime. That can raise this implication that is defamatory. Inside an article, there can also be implications. So, for example, if you talk about a particular company in one paragraph, and then the next paragraph talks about companies that have committed tax fraud, and you don't, directly connect the two. You don't directly connect the company mentioned in the first paragraph with the companies guilty of tax fraud in the second paragraph, but because they're right next to each other, it could lead a reader to assume that one is related to the other. That might be a defamation by implication situation. So it's important to take a step back and think about, would a typical reader connect these things that I don't mean for them to connect? Or come away with some fact that I don't know is true, that I'm not reporting as a fact, but is implied in what I'm writing. So here's an example of the defamation by implication from a real case. This was an ad put out by the New York City Division of Human Rights several years ago. They launched an ad campaign to educate people with HIV about their legal rights. So you can see at the top of the ad, it says, "I am positive," and that talks about the rights of people who are HIV positive. And it shows this woman, or this is a photo that they licensed from a stock photo library. So the model in this photo wasn't posing for this ad. She just posed for the stock photo agency. And she also wasn't HIV positive, but obviously the ad implies that she is. Doesn't directly say it, but there's a clear implication. So she actually sued New York City for falsely suggesting that she had HIV, and she won. The court found that she was defamed and awarded her some money. So this is something that we often look for in our pre-publication reviews. Things like photos suggesting something that isn't true about the people in the photo. And in some cases, news organizations will use stock imagery like this just to illustrate a web story or whatever it may be. And there, it's important to think about, are there people in the images that we may be implying are the subjects of the articles? With stock images, sometimes depending on the agreement between you and the company that supplied the image, there may be some protection there, but it comes down to the agreements you signed. And in this case, there was no agreement that protected the city against claims like this from people appearing in the stock photos they were using. So that's defamation by implication. And I'll move on to the next element of defamation, which is a statement of fact. Only facts can be defamatory, opinions cannot be. And whether something is a fact or opinion generally is pretty straightforward. A fact is something that is capable of being proven or disproven. An opinion cannot be proven true or false. But the thing to be aware of here is to watch out for opinions that, or statements that masquerade as opinions but are actually facts. So something like, "I think he committed murder," is is dressed up like an opinion. It starts with I think, but whether or not somebody committed murder is a fact that can be proven true or false. So a statement like that, I think he committed murder, could still be a statement that could lead to a defamation claim. So now, next element, statement can only be defamatory if it concerns a person who's identifiable in their community, is the standard here. So basically, a large group of people who are not individually identifiable can't be defamed. You can say anything about the French, and it's not going to be defamatory. But if you say something about a particular person from France, that can be defamatory. So it has to be of and concerning a person. The thing to watch out for here, though, is just because you leave out a person's name doesn't mean they're not identifiable in their community. So if you give enough details about a person in an article, even without naming them, if you've given enough details that other people in their community can say, oh, I know who that is, I know who they're talking about, then the statements are still of and concerning that person and could still give rise to a defamation claim. So next element, even if somebody shows that you've made a false statement of fact of and concerning them, they also have to show that it caused harm. So what's harmful? This is really anything that harms a person's reputation, anything that tends to expose a person to hatred, contempt, or aversion. It's usually pretty clear what's harmful and what's not. Saying positive things about a person, even if the things are not true, isn't going to give rise to a defamation claim. Then they have to show that the statement was published. And this is an area people sometimes get tripped up with, because published in the defamation context just means shared with any third person. So it doesn't have to be published, formally on a website or in print or anything like that. Just shared with anyone else means the statement was published. At the most extreme, that means if you're just texting something to somebody else and it's just you and them on the text thread, that is publication for purposes of defamation law. Now, of course, if it's just you and one other person on the text thread, that's not likely to lead to a lawsuit, because how would anybody ever know? And what would the damages be? It's not going to be enough to warrant a lawsuit. But just sharing it with any other person is enough for publication. What that also means, though, is anything published on social media is published for purposes of defamation law. So it's important to not only be paying attention to defamation risks in your articles, things on your website, but also everything else you're publishing on social media or email newsletters or anywhere else. And actually, social media, going back to the defamation by implication, the photo risks, social media often raises those kinds of risks where there's a photo with less context maybe than is on the website, or there's a photo that's thrown into a carousel of photos where it doesn't really fit or doesn't really belong. That's something to watch out for, that you're not including photos on social media posts that are taken out of context or presented with different context than is on the website, in a way that somebody might come away with an implication that you didn't intend. I'll also bring up at this publication stage the republication rule, which is another area that often trips up news organizations and can lead to liability. So the republication rule says if you republish someone else's defamation, you're still liable for it, even though it came from somebody else. And this includes things like quoting people. So if you're interviewing somebody and they say something defamatory, if you then include that statement in the article, even though it's in quotes and attributed to the person who said it, by republishing it, you are equally liable for the defamation, just as liable as that person is. So this often obviously gets news organizations in trouble because a lot of people don't think about this as a defamation risk, thinking, well, if I'm just quoting the person and it's not my words, it's their words, how can I be liable? But under this rule, they are liable. And then also there's often a situation where the person saying the defamatory thing, it may be newsworthy that this person said this thing. So because it's newsworthy, you need to publish it, and that's fine. It's important to publish newsworthy things, and if a statement from this person, say it's a mayor, a political figure, the president, if they say something that is defamatory, but it's an important newsworthy thing that they said, you can still publish it as long as you provide the context, the other information surrounding that statement that you're aware of that gets at the truth. And I'll talk about this idea more when we get to this last element. As long as you're including the information you're aware of that's true, the context you're aware of, and you're doing your best, you're following journalistic standards in an effort to get at the truth, then if you do have this situation of a newsworthy statement that is potentially defamatory, you should still be protected in publishing the newsworthy statement and publishing the surrounding facts that put the statement in context. But putting that situation aside, putting aside the newsworthy statement situation, it is important to remember that any quotes, anything else you publish, you can be liable for, even if they came from somebody else. Last thing I'll say on this element is the fair report privilege. This doesn't really fit into the publication element of defamation, but I'm including it here because it's important to include somewhere. So the fair report privilege protects you from basically this republication rule if you are accurately and fairly reporting on proceedings that happened in a court, in a legislative session, in an administrative session, then you have this privilege against defamation liability. So say you're reporting on a trial in court and a witness says something that is not true. It meets all the elements of defamation, so it's a defamatory statement. You can still report that under the fair report privilege and not be liable for defamation, even though typically, because you're quoting somebody else and the quote was defamatory, typically you would be liable under the republication rule. But because you're accurately reporting on something that happened in a judicial proceeding in a court, the fair report privilege makes it a privileged report. It protects you from defamation. And the rule here exists because the law thinks it's particularly important for people to be aware of what's happening in courtrooms, in legislative sessions, in other administrative government proceedings. So they want to protect news organizations in reporting on what happens in those proceedings. The important thing, as the name implies, a fair report, the important thing is your reporting on the proceeding is fair and accurate. It's important to provide the context in the proceeding. If there's some contrary information you're aware of that contradicts the thing you're reporting on, you should include that. And you should also be clear in articles about what information is coming from those government proceedings, where the fair report privilege would apply, and what information isn't. But the fair report privilege is an important tool to protect yourself from legal liability. And any opportunity you have to use it, you really should. So if you have a choice between quoting something from a document that's been filed in court versus to get the same information quoting a source who you interviewed, it's going to be safer to quote the court document rather than the source, because then you'll get the fair report privilege. All right, so finally, we get to the state of mind requirement. So if this defamation plaintiff has proven that a statement is a false statement of fact about them, it caused harm, it was published, they still have to prove that you acted with either negligence or actual malice. And the standard for private people is negligence, meaning the journalist didn't exercise the minimum level of care expected of journalists. And then for public officials and public figures, the standard is actual malice, meaning the journalist knew it was false when they published it, or they acted recklessly about whether it was false, meaning they entertained serious doubts as to the truth of the statement. Now, who are private people versus public figures? The line is pretty gray. It is not made very clear in the law. So it's really a case-by-case determination, and it's hard to give any general guidance other than if we're talking about a person who is well known in your community, who the typical community member would be aware of, they're likely to be a public figure. And if they hold a position of authority in government, they're going to be a public official. Public officials are generally clear. But yeah, so public officials and public figures have to prove that the statement was made with actual malice. And I'll talk more in a second about the standards for how courts determine whether something was actual malice, what that phrase actually means. But I want to turn to an example where this negligence versus actual malice distinction came into play. So this is Don Blankenship versus NBC and a number of other news organizations. Blankenship, you may remember, was the CEO of Massey Energy in West Virginia. They owned the Upper Big Branch mine, where there was an explosion back in 2010. It killed a number of workers. And Blankenship was indicted after the explosion on a number of federal charges, a bunch of felony counts. He went to trial, and the jury ultimately acquitted him of the felony charges, but convicted him of one misdemeanor charge for conspiring to violate mine safety laws. So then fast forward, in 2018, he announced he was going to run for US Senate. And during the Senate run, there were a number of news articles that described his previous legal troubles and referred to him as a felon or a convicted felon, which wasn't true. He was not a felon because he was acquitted of the felonies. He was convicted of a misdemeanor, which made him a criminal or a convicted criminal, but not a convicted felon. So he sued for defamation, and he ended up losing because the court held that he was a public figure. As CEO of this large company in West Virginia, that made him a public figure, and he was running for office. So he wasn't a public official because he hadn't won the election, but he was a public figure because he was this high-profile person. So the court first held that he was a public figure, and then held that there was no actual malice in the descriptions of him, because the evidence showed that in some cases, the journalists who described him as a felon didn't realize the distinction, that felon meant convicted of a felony. In other cases, the journalists had forgotten that he was only convicted of the misdemeanor, not the felonies. But in any event, the evidence showed that the journalists had not known that the statements they made were false, and did not entertain serious doubts about the truth of the statements. So it wasn't actual malice. But I point out this case because it really turns on the fact that he was a public figure. If he was a private person and only had to prove that the journalist acted with negligence, he might have succeeded in this lawsuit. So, what are some of the things that courts look for in determining whether a journalist is liable under the actual malice standard? Things like whether the journalist fully investigated a claim, um, intentionally avoided sources that would provide the truth of a claim, if the journalist relied on unknown or untrustworthy sources, if they went into an article with a predetermined intent. So if there's evidence that they weren't just trying to seek the truth, but were trying to establish a predetermined storyline, that can be evidence of actual malice. And then profit motive, and if the claim was inherently unbelievable. None of these things by themselves establish actual malice, but these factors together can lead to a court's conclusion that there's actual malice. So this goes back to what I was saying at the top, that following good, solid journalistic practice will generally protect you from these sorts of claims. Having multiple sources, having reason to believe the sources are trustworthy, going into an article with the goal of finding the truth. All these things are things that journalists always do, and things that can protect you from being found liable in this situation. So here's another recent example: Young versus CNN. You may be familiar with this case already. It goes back to November 2021, and the U.S. pull out from Afghanistan. CNN aired a story about people trying to flee Afghanistan, and the story said that there were private contractors who were charging these exorbitant fees for black market evacuations. So it talked about these black market evacuations, and then later in the story, almost separate from that, it mentioned one contractor, Zachary Young. It showed his photo, and he was a contractor who was hired by corporations and NGOs to help rescue people from Afghanistan. So the article and the TV piece, it never actually said that Young was doing anything illegal. It didn't say that he was one of the contractors involved in these black market evacuations, but he was the only contractor named in the piece, and it arguably suggested that he was one of those contractors who were doing something wrong. So Young sued CNN for defamation. CNN actually lost at trial, and the jury awarded Young $5 million. And the evidence that came up during discovery in this case was not helpful for CNN. So apart from just the juxtaposition issue, where they talk about this wrongdoing by contractors, and then they show his face and give his name as the only contractor mentioned. It turned out they also had these internal communications that came out in litigation that may have swayed the jury. It was certainly embarrassing for CNN. These were things like Slack messages internally that talked about how we're going to nail this guy, what a punchable face he has. These were embarrassing communications, to say the least. And then they were used by his lawyer to show that CNN had it out for him, really, that they weren't trying to seek the truth in this article, that they were just trying to nail him, regardless of what the truth was. So the important lessons here are a fewfold. First, again, follow facts where they lead. It's important to not start off the reporting with the goal of tearing somebody down. Not that that's what CNN actually did here, but that is what these messages can be used to portray, can be used to make it look like CNN came at this from the start, trying to tear this guy down. But then the second piece of advice here is, the standard kind of advice: don't put anything in writing that you don't want to see on the front page of a newspaper, right? Because regardless of what the journalists at CNN were intending, what good work they were doing to fact check the piece, regardless of what they actually had in their minds, communications like this don't look good and can be shown to juries to make it look bad for journalists. So it is important to think about not only what you're putting in writing in the articles themselves, but also internally what your communications are saying about you and about the journalistic process. Now, that doesn't mean you need to be like super couched in everything you say internally. It's of course important for reporters, for editors, for everybody to have open and frank communications about articles. But it is a good idea not to personally go after people who are mentioned in articles in this kind of direct way that's not talking about the substance of them or the reporting or the article, but it's just talking about them as a person. It's best to avoid that kind of communication. So I think I'll skip ahead a little bit. Um, One other thing, this case is another example where a number of um, those factors that courts consider in whether there's actual malice, a number of those factors came up. This is the old Rolling Stone article about an alleged rape at a UVA fraternity. Turned out not to be true. Columbia Journalism Review did a deep investigation of what went wrong, and it's worth a read because the investigation really highlights how the journalist and others at Rolling Stone, had the best of intentions. They were trying to report on this very sensitive situation with this sympathetic source. They were talking to the alleged victim of the assault, but because of the sympathetic nature of her story, they weren't going through the standard journalistic steps of finding other sources and trying to confirm every fact that they could confirm. And then it turned out that it bit them because the facts weren't true. So the Columbia Journalism Review did this great investigation into what went wrong that's useful just as a reminder of how to do journalism well and follow the facts where they lead and do everything you can to establish the truth of what people tell you. So just practical tips now to summarize the defamation discussion. Putting in work to corroborate information, of course, is critical for any journalist. Being skeptical, especially of sources that you tend to agree with. It's important to be skeptical of what they're telling you. Um, Important to be skeptical of every source, uh, and assess the accuracy of sources. If you have any reason to think that a source is not telling the truth, then it's even more important in that situation to get additional sources. Another important thing, and this comes up a lot when we do pre-publication reviews for articles, is providing a meaningful opportunity for people to comment. Anyone who is identified by name in an article, and this goes for people or companies, anyone who's identified by name in an article and there's something negative written about them in the article, they should have this meaningful opportunity to comment. And what does that mean, meaningful opportunity? It means they should know what it is that you're going to be writing about them. So not just like, oh, I'm writing a story about this broad topic. Do you want to comment? But but actually putting the allegations, putting the negative facts about them, um, putting those directly to the person. Um, Often it's good to do this in email, so then everything is written out. You have a record that you put these questions to the source, and then you give them an adequate amount of time to respond. Um, and what counts as an adequate amount of time is going to depend on the situation. If it's this big investigatory piece that you've been working on for months, and there's a lot of information in there, you're going to want to give them more time to potentially respond than if it's a breaking news story, obviously. So it's really dependent on the situation, but it is important to be able to show that you gave them this full and fair opportunity to comment. And then, finally asking yourself, have I done everything I can to make sure this is right? Um, Always an important step for journalists, and also an important step for protecting yourself from defamation liability. So I'll move on to protecting sources. So this is there are kind of two angles to protecting sources. One is protecting them legally, like the legal protections you have for protecting your sources, but then also protecting them from unintentional like leaks of information. So I'll talk a bit about digital security too to prevent information from getting out when you don't intend it to. But first, your legal protections. New York has this really powerful shield law for journalists that protects journalists from having to give up information that they haven't intended to give up. And the shield law has two parts. First, there's absolute protection for confidential sources. So if you have a source who you've promised confidentiality to, then the shield law uh, protects you from having to give up anything about that source, including their name, including any information you got from them. And it's absolute protection. The shield law doesn't provide any exceptions to this. So whether it's the government trying to get this information from you, or a private litigant who's involved in a lawsuit, as long as you've promised confidentiality to the source, and that's the key, there has to be a promise. As long as you've promised confidentiality to the source, then the shield law gives you that absolute protection from having to give up information. For any other sources or other information, the shield law provides a qualified protection. So this covers any information at all that you haven't published. So this is names of sources, information from sources. This is information in your notes or in draft articles that weren't published. Any unpublished information gets this qualified protection, which says that you don't have to give it up to anybody else unless the other side can show that the information is highly relevant. Um, it's a three-part test. They have to show the information is highly relevant to the claim they're trying to make, or if it's the government in a criminal case, highly relevant to their criminal prosecution. They have to show it's necessary, which means they can't pursue their claim. They can't legally pursue it without this information. And third, they have to show they can't get the information from any other source, that you're the only source they can get the information from. So that's a very difficult test for parties to meet. They typically don't meet the test, and the information is typically protected. But if they can meet that test, and the information is coming from a source that was not promised confidentiality, then in that limited situation, the journalist can be required to give up the information. So that's the New York Shield Law. It is a state law, so it doesn't apply in other states, and it doesn't apply at the federal level. Generally, there's some argument about whether it applies at the federal level, but There's no similar federal law. At the federal level, we have to rely on kind of broader First Amendment principles, and oftentimes at the federal level, journalists can be forced to give up information. Um, so it can be riskier at that level. But at the New York state level, we have this really strong protection. Um, Now, apart from the legal protections, it's also important to protect information in other ways. So digital security is critical these days for preventing, hackers, preventing unintentional leaks of information, and also making it harder for the government to get information from you if they're going to try to get it from a device. Digital security is all about trade-offs. You give up some convenience in exchange for some security. So it's hard to come up with any one size fits all recommendations. But for more sensitive communications, you should consider end-to-end encryption. So this is things like using Signal for text messaging, using Proton Mail for email, and using special apps like that are different from what you normally use that can lead to some inconvenience. So it might not be necessary to use them all the time for every article. But if you have a particularly sensitive source, if you're working on a particularly sensitive story, you might consider moving to the more secure encrypted communication apps for that. Same thing with putting information in the cloud. So a lot of news organizations use like Google Docs, Google Drive, cloud services like that. And that's fine on a day-to-day basis. But by using a third-party service, you are putting more information in that third party's hands. So again, if you have a particularly sensitive source or situation, consider keeping information about that on your own computer rather than on something that stores it in the cloud. Same kind of idea with AI services. So a lot of times on Zoom, there are these AI note takers, and it's the same idea where the information is being stored typically on another company's servers. You have this third party in the mix. So so if you have a sensitive situation, it's best to leave those AI note takers out. Anytime we meet with clients where it's an attorney-client confidential situation, we make sure not to have any AI systems involved in the Zoom. And then more general advice: make sure to keep your devices updated so that they have the most recent patches and security fixes, and to protect them with strong passwords. Strong passwords are long passwords. Usually, the longer the better. Um, and change the passwords from time to time as well. So lastly, I'll say a bit about the right to record. New York, as I'm sure many of you know, is a one-party consent state. So that means as long as one person, one member of a conversation consents to recording a conversation, then it is legal to record. You don't have to get consent from everybody. And that means that if you are talking to somebody and you consent to yourself recording, then you can record. You don't have to get the other side's permission. Um, Not all states are one-party consent. Some are all-party consent, which requires that everybody in the conversation agree to be recorded before it's legal to record. So it's important to keep in mind, especially if you're talking to somebody in another state, right? If you're in New York, the other person's in another state, it's important to know what that state's laws are, or just to get the person's permission before you record. Recording in public spaces, you have a right to record if you're in a public place where the public has access to and where there's no expectation of privacy. You have a right to record in that space. So streets, sidewalks, public parks, you can record in without getting anybody's permission. And then recording police. So New York State has a law that enshrines the right to record law enforcement officers. It says everybody has a right to record police as long as the person doing the recording is not under arrest and is not physically interfering with law enforcement. So it is important to stay back a reasonable distance. What is a reasonable distance will depend on the situation, but certainly not be so close that you can touch the police or physically interfere with what they're doing. Now, this is a state law, so a bit like the Shield law, there's less protection at the federal level. The Second Circuit Federal Appeals Court, which covers New York, hasn't directly said whether people have a right to record under the First Amendment. But other circuits, other federal courts around the country have said that the First Amendment protects the right to record, and that's generally what we expect the Second Circuit would say. So you do have a right to record police both under the First Amendment and New York State law, but of course important to stay back, to not do anything that the police could then come and say you were interfering. So with that, leave it to questions. If anybody has any, happy to discuss anything.
Yeah, if people want to drop questions into chat, they could start doing that now. So, Michael, one of the things that came up before is you showed these internal messages from CNN. And I think as journalists, we kind of have this impression that our communications are protected, but then you're seeing internal communications among employees had to be handed over because they got sued for libel. But at the same rate, we have shield laws and we have confidential sources. So what if a story is based on a confidential source and you are getting sued for libel, and now you're supposed to hand over communications for this lawsuit, but those communications could also identify whoever your source is?
Yeah, that's a really good question. And it's a difficult situation where those information protections kind of meet the requirements of discovery. Because typically in a lawsuit, when somebody files a lawsuit, the first thing you'll typically do as a defendant is try to get the lawsuit dismissed, right? File a motion to dismiss. If that's denied, then you move into discovery. And the discovery rules in a typical case are pretty wide open. Anything that is potentially relevant, a party can request, and you have to produce to the other side. But you're right, then the shield law comes in, and if it's a confidential source, that can't be requested under any circumstances. So you're going to be protected there. If it's not a confidential source, so those communications from CNN, they were just the opinions of journalists. So it wasn't information that was coming from a source who had been promised confidentiality. So in that case, because it was unpublished information, actually, it wasn't even information from a source, so the New York Shield law wouldn't have applied in a situation like that. But say that the journalists were sharing information they got from a source, not a confidential source, just any source. Then the other side would have to show that the information they're trying to get is critical to their claim. They wouldn't be able to pursue the claim otherwise. And in that kind of situation, maybe they'd be able to show it. If they could say, look, we have to prove actual malice in this defamation suit. To prove actual malice, we need to show what the journalist had in mind. Um, Maybe they'd be able to overcome the protections there.
Hmm.
But because the CNN communications weren't talking about information from sources, they were just talking about the journalist's opinions and thoughts, then the Shield law wouldn't come into play.
We had a question that came in that was about publishing, and you got into this earlier, but they said, does that include sending an email?
Yeah, so if you're sharing information with any other person, whether it's email, text message, anything, then that does count as publication for defamation. Um, but again, the risks of a defamation lawsuit are pretty low if you're just emailing one other person and it's not the person who you're saying something negative about. Like, how's the plaintiff going to find out? Um, so the risks are low, but just an email would meet the publication element of defamation.
Yeah. There was a similar question that was, does publishing include internal communications with an editor? So if you're a reporter and you're like, hey, I got this hot tip, and it turns out that the hot tip turns out to be not true, can you be liable because you emailed your editor something that is defamatory?
So the email with the editor would meet that publication requirement. But I don't think you would be liable there, for a number of reasons. One is the realism of how is anybody going to know, but also if you're just saying, oh, I got this tip, I want to check it out, you're not claiming that that's a fact, right? You're just saying this is something we should investigate. Um, so that wouldn't be defamatory because you're not coming out and saying, that this is true. It wouldn't meet, certainly not the mindset element. It wouldn't be negligent or actual malice. Um, and you might even argue that it's not a statement of fact, but certainly not the negligence.
We have a question from a group of reporters from Rickner Communications, which is they publish the Herald Community newspapers. With Don Lemon's arrest today, to what extent can we realistically trust the law to protect us, especially from federal agents during protests?
Yeah, so that's a really good question, and of course a big concern in media law these days. And I I don't really have anything encouraging to say on that front, other than we'll see how the Don Lemon case goes. It seems like a very weak case, um, and outside of the current administration, I don't think any Justice Department in the past would have pursued a case like that. So it I guess like a note of realism, about all this stuff is people can bring whatever case they want, right? Even if you've protected your journalism, like in the defamation context. If you've protected your journalism, you haven't. It's clearly not defamatory. Somebody can always file a lawsuit saying it's defamatory, and they'll lose in the end. Um, but there's nothing you can do to stop them from filing the suit. And kind of the same thing with the Don Lemon situation.
So, with a situation like this, like say you have a group of protesters or whoever they may be, and you're embedded in that group as a journalist. They know you're a journalist. You're not like undercover. So you're embedded in a group, and they do something like trespassing. If you follow them into a building or a courtyard where you're not supposed to be, are you now criminally liable for trespassing? Is there no, I'm just a journalist defense?
So there's no defense, like that. Journalists are subject to the same laws as everybody else. So if it's trespassing for everybody else, it's trespassing for journalists as well. This is kind of where traditionally the journalist would not be prosecuted, but legally, um, yeah, there's no exception for journalists in that situation. I would say to protect yourself as best as possible, it's important to make it clear in the situation that you're a journalist, you're not a participant, right? And so maybe standing apart from the participants, maybe having your press pass clearly visible, taking steps like that can help. Um, but but yeah, you're still liable for trespass. Um, and uh, yeah, I I think in general that's all I can say. Just make it as clear as possible that you are a journalist, not a participant, and you're there to report on what's happening, not to participate in it.
Hmm. So before you brought up Google Docs, and there's things like Otter, where I use Otter a lot to record interviews, and I'm doing a lot of interviews that aren't sensitive. But if I was using like a confidential source, I wouldn't put it on this third party app. And what if somebody sues Otter to get my recordings instead of suing me, and then I might not even know that it's happening. But there's a deletion question. So we used to discuss having a newsroom policy of like after 6 months, we destroy or throw out our notes. And that policy made a lot of sense when all of our notes were on pen and paper. And even if they're on your desktop, you might periodically clean up space in your desktop. Now we have cloud storage like Google Drive. So I take notes on my Google Docs app and they live forever. I can go into Google Docs and delete stuff, but I really don't need to because I never run out of space. But what if there's some things in there that I just don't want to live there forever? If my thought is, if somebody wants to sue me a couple of years later, I don't want them to find this, but isn't that bad too? Like you have some records retention responsibility too, don't you? How do you find the balance between I don't want to keep sensitive things on the cloud forever, but I also don't want to get in further trouble because I was seemingly destroying evidence that could have been used against me in a defamation lawsuit?
Yeah, so where people get in trouble with lawsuits is destroying documents after they're aware of a legal claim against them. So definitely if you've been sued or if you have reason to expect that you could be sued about something, then you should preserve all the documents. But if you have no reason to expect there's a lawsuit coming, you can do whatever you want with your records. The safest thing is to have, like you mentioned, the records retention policy. So you're just deleting records, pursuant to the policy, and then it's if anybody comes along later and complains, you can say, well, this was our policy. This is what we did. Um, that's the safest thing. But again, you can do whatever you want with your records when you have no reason to think that there's any legal suit coming. Um, so yeah, you can handle that as you'd like.
Hmm. So if anybody else has any other questions, pop them into the chat. You could raise your hand. You could even unmute yourself at this point.
So I'm actually going through something very similar on your last topic. I recently filed a writ of mandamus against the city of Richmond over a FOIA suppression involving them refusing to secure a data preservation request because an electoral board member I have found was keeping all of her communications on a personal cell phone and a personal AOL account. And they refused, inaccurately, according to Virginia FOIA law, to parse her personal devices.
Yeah,
Any
so
advice on that?
yeah, so public records laws are um, are very different from what I was saying earlier about how you can handle your records as you see fit. Yeah, if it's a public official doing public business, all those records need to be preserved. The law requires that regardless of whether the records are on a device owned by the government or a personal device, um, they all have to be preserved. Now, if the deletion has already happened, at the end of the day, there might not be a whole lot you can do if the records really are gone. But yeah, there's that legal obligation, and who knows? Depending on the situation, there might be a way to recover the data. And if there is, then the agency would be presumably required to do that. I'm not familiar with Virginia's version of the law specifically, but in general, that's what I would expect that the agency
It,
would have to.
Virginia FOIA law is pretty robust, which is a very good thing. But I have
Yeah,
a standing rule. I kind of have a mix of Sun Tzu and Machiavelli in how I do things. Uh, and it's important for journalists to understand utilizing their acts of suppression, their silence, their refusing to do things according to law is a weapon, a tool that you as a journalist can utilize. And I think some people miss that. So if they have deleted all of those records, which I'm pretty sure they have, that's not necessarily a bad thing.
Well, there's definitely a shaming aspect that comes into this, whereas a lot of FOIL and open meetings law, very hard to enforce when you have a body that doesn't want to enforce it, or nobody speaks up that open meetings law is not being followed. Sometimes the only tool that you have is shame. And I know that Michael, as an attorney, might feel there's more that you could do. But I know as a journalist, sometimes we get further by publishing stories than we do by going through the FOIL process or trying to enforce open meetings law when we actually don't seem to have any enforcement tools.
yeah, yeah. It's really true that a lot of times you do see more movement that way than through the legal process.
And Robert had his hand up.
Yeah, my question is, if you're sued for defamation and they lose, are the conditions under which you can countersue them for damages?
So there, sort of, there's an anti-SLAPP act in New York, and you may know this already, but SLAPP is an acronym, Strategic Lawsuit Against Public Participation. So a SLAPP suit is where somebody sues you not so much because they really want to win the lawsuit, but because they're trying to punish you for your reporting or your speech, or they're trying to silence you. And New York has this anti-SLAPP law that that does allow you to. It basically changes the order of operations in the lawsuit, to hopefully get you out of the lawsuit faster, and then you can get some fees from the person. So it's not so much damages. It's mostly just attorney's fees, so that you're not having to pay your lawyers at the end of the day out of your own pocket. Um, so it helps, but it's not so much like traditional damages, where you've been injured and they're compensating you for that.
Thank you.
John, I know you were unmuted. Did you have a question, John Rigrod?
Yes, I do. Question would be, if I promise someone that I'm not going to name him or her, and down the line I have to, can that person come after me because I let him or her down?
Yeah, interesting question. So there is, I mean, first of all, I think the primary issue there is like journalistic ethics and practices, and whether the situation requires disclosing the person's name. But there is some case law that that establishes a promise of confidentiality as like a contract. So then if the journalist breaks that agreement, it's a violation of contract and they can be sued under that theory. So it would really depend on the facts. For the
Well,
source to argue that it was a violation of a contractual promise, there would have to be a give and take where the source can show that they only spoke to you or they only gave you information in exchange for this promise.
well, that's the
Um,
point. When you
yeah,
promise that, and then they give you the information, and let's say we have a New York law, but the federal law comes over that. And for whatever reason, I now have to divulge that Mary Jones told me this and that. I promised Mary Jones I wouldn't. Where am I? I've been forced to do it.
yeah, I see. If you've been legally forced to do it, I think that the source's argument would be weaker. Trying to think, I don't think I've seen a case like that before.
Kind of
But
interesting because what
yeah,
if you promised, hey, I would go to jail before I would give you up as a source, and then you get sued in federal court and you lose and you give up the source and you didn't take the step of going to jail. Now maybe you have opened yourself up to a lot of liability, even though you've obeyed a court order. You've you've broken this vow.
Mm-hmm.
yeah, yeah. I think it would get tricky for the source to win in that situation still, um, because the your promise would basically be, I will violate a court order for you. And I don't think a promise like that would be legally enforceable. Um, but it certainly would be a tricky situation. So, my suggestion would be not to promise anything beyond what you'd be willing to do. Like if you really would be willing to go to jail, then promise that. But if in a situation where you got a court order requiring you to disclose it, if you think you would just disclose it at that point, then best not to promise that you would go to jail to protect it.
Well, knowing what we've learned today, how can you make that promise unless you put a caveat on it? I promise unless I'm forced to. I mean, how do you not get in trouble for your big mouth?
Yeah, I would say, like, I'm gonna keep your name or information confidential. I'm gonna do everything in my power to keep it confidential. Anything I can legally do to protect it, I'm going to do that.
Mm-hmm.
So yeah, adding a caveat to say, like, I'm going to do everything I can legally, um, would probably protect you as best as you can.
Thank you.
We had a question from Nori. She mentions being in a couple situations in the field. One, she has an on-the-record public official names another official and makes critical claims, for example, saying they're inciting things. What's the best practice when you follow up with that second official? Do you directly attribute and quote the first source, or do you paraphrase more generally to reduce defamation risk? I guess that's the interesting situation. You have one elected official saying something potentially defamatory about a second elected official. When you go to that second elected official to get the response, how much of that can you repeat without opening yourself up to liability? And the second part is, if you're pressured by a public official to reveal your sources, like homeless death figures, what are the best practices around protecting your news gathering? When are you ever obligated to disclose something? I think from what we kind of just discussed, you're never really obligated to do anything until there's a court order, but there are best practices too.
Right. Yeah. From a legal perspective, if somebody just asks you for information, then yeah, you're not obligated to give it up. But apart from the legal side of it, there are a lot of reasons why you might want to share the information. Um, on the first part of the question, if somebody says to you something that may be defamatory, and then you go to the person they are talking about to get their response, I don't think there's really any defamation risk there, because you're trying to find the truth, get their response. So there would be no claim that you were acting negligently, because that's what a journalist does, is get information, get people's responses to statements, and it's not like you were portraying the statement as truth. You were just trying to get more information. So I think that would be a safe thing to do. Either to quote the first source or to paraphrase it would be fine. And then go from there, because that really is what journalists should be doing, is gathering more information to try to find out what's true.
And Ann Parry, I saw there, kind of shocked me. There was a sign that was not there because of the event, but it was a sign outside of the town hall meeting room, and it said no photography or recording. And I saw this sign and I'm like, they can't possibly keep this sign up during public meetings, right? Because you're allowed to photograph and tape and record a public meeting under all circumstances, aren't you? What is my recourse if I'm at a public meeting and I take my phone out and I start recording and the chairman stops the meeting and says, you have to stop. If you don't stop, we're going to throw you out. Do I sit there and say, sorry, I can keep recording under open meetings law? Or is it better to just stop and try to challenge it in some other way? And I know there's a difference between photographing from your seat and moving around the room. But as long as you're not creating a disturbance, is the best thing to do to stand my ground and continue recording?
Yeah, so you're right. If it's an open public meeting, it's open and public. So there's no need to no reason to restrict recording. And yeah, that it's a little situation dependent, but I think it probably would be best to stand your ground and explain that any member of the public has a right to be there and to record it. And then if they keep insisting, you can always contact us and we'll fight the issue, which doesn't help you a whole lot in the moment. But in the longer run, if it's a policy they have that they're trying to enforce, it's important to get the policy reversed. So yeah, in the moment, I think that would be great to stand up and assert your rights, and then over the longer run, contact us or another lawyer for more legal avenues.
Thank you. I think we got to everybody's questions, but we do want to let Michael go because we've been running for close to 90 minutes here. But I want to thank you again for doing this. And what's the best way for people to stay on top of what the Cornell Law School First Amendment Clinic is doing?
Yeah, so first, my email. I just put my email in the chat. It's mml89@cornell.edu. So feel free to email about any legal issues, and I'll try to help. If I'm not able to help, I can often refer you to someone else. And then the clinic itself, we have a website. If you Google the Cornell First Amendment Clinic, where we update on our cases and also talk a bit more about the various legal services we offer.
Wonderful. All right. Thank you so much, Michael, for doing this. Thank you, everybody, for joining us. And I will post the recording in the coming days to the Press Club of Long Island YouTube channel and Facebook. So if you want to replay it, you can do it there. Also, check out pcli.org. We have our past presentations there. There's a journalist resource section where you will find our previous meeting, Cornell, where we covered freedom of information law and open meetings law in great detail. All right. Thanks, everybody.
Yeah, thanks, everybody.